May it please the Court, my name is Joel Rosen, and I represent Stephen Chadwick. This is a case where the Board of Registration in Dentistry interpreted a regulation over which they had no jurisdiction and no expertise, and they got it wrong. And they compounded their error by using that incorrect legal conclusion to make an incorrect finding of fact. Basically, they said, if Dr. Chadwick disagrees with us or doesn't understand what OSHA regulations require, then he must be wrong on the facts too. He can't have complied with them, and therefore we are free to disregard any evidence in his favor, even if...
Let me make sure I understand. Is it your position that the state doesn't have its own regulations, that this is only about OSHA regulations?
The state has one regulation, Section 18 in the CMR, that says dentists should comply with the CDC recommendations for practices in dentistry. The CDC regulations don't incorporate OSHA. Basically, there are recommendations, which is what you're supposed to comply with, and then there's an introduction. And in the introduction, so the recommendations themselves don't import OSHA into the CDC regs. There's OSHA is only mentioned in the introduction, and what it says is that dentists, in addition to our recommendations, should comply with the OSHA regulations that cover employee safety. So you don't even get to, the OSHA regulations are not state regulations. They're just a...
I'm sorry, finish.
Yes, go ahead.
Are you saying that the state could not have lifted the words out of the CDC regulations and lifted the words out of the OSHA regulations and promulgated them as their own? Could they have done that?
Well, the state can, under OSHA, the state can displace...
Forget about OSHA. OSHA's, they just plagiarized the terms out of OSHA and out of CDC and stole them and kept them as their own and put them in the state regulation.
No, I don't think they could, because they're regulating, that's the Gade case. They're regulating in the same area where OSHA has exclusive jurisdiction.
So it's preempted.
It's preempted.
But surely the professional licensure is really not something OSHA has anything to do with. The federal government doesn't regulate the licensure of dentists, the professional licensure of dentists. That's purely and totally a state matter.
That's
and
right.
We can say dentists can do X, Y, or Z, or they can't do X, Y, and Z. And isn't that totally within, in order to keep their license, isn't that totally within the state's purview?
The state can make any regulation that's permitted under the police powers for the regulation of occupations, other than regulations that are preempted by federal law, by the Supremacy Clause.
Well, we're talking about revoking his or suspending his professional license.
Right.
So what's that got? So I don't understand. We can't say if you, Mr. or Ms. Dentist, don't maintain certain standards, which OSHA, by the way, has set, then we're going to revoke your license. State can't do that?
There are certain state regulations that are not identical to OSHA regulations, but for example, the state has its own hazardous waste regulations, which don't actually enter the field occupied by OSHA. Certainly, the state can enforce its own hazardous waste regulations.
Isn't your problem, though, I mean, isn't your problem not so much that the state couldn't appropriate OSHA and apply it? It's you're saying, well, the problem is that the state, in doing so, has misapplied what OSHA says, and OSHA has the power and authority, and the state can't interfere with that to interpret its own regulations, and the state can't interpret them in a way that OSHA doesn't, isn't?
Yes, Your Honor, that's part of it. The goal of OSHA is to set a uniform regulation of workplace safety. And one purpose of that has to be that employers and practitioners shouldn't have to guess about what standards they have to meet. So in that respect, that's right. The state, Dr. Chadwick certainly has to comply with OSHA. He's an employer. But it's not for the state to say whether or not he's violated those regulations.
So he cannot be, his professional license cannot be revoked on the basis that he's violated OSHA regulations. Is that what you're saying?
No, that's not what I'm saying.
That only OSHA can revoke his license, but they have no jurisdiction?
OSHA could come into his office and say, you violated OSHA regulations. If they did that...
But they can't revoke his license because they've got no
can't.
authority over his license.
They can't. Then the board could come in and say, as if he had committed a crime, and there are many cases, and we cite them in our briefs, where other boards have revoked professional licenses because someone committed a crime, like a gun violation or some other...
But you're saying the Board of Dentistry can't make a finding that OSHA violations have occurred without OSHA having made that finding?
That's exactly what I'm saying.
Except in the circumstance, just to clarify, that Massachusetts had submitted a state plan to take responsibility for all those.
Well, that's right.
Which everybody agrees did not occur here.
That's exactly right. That's Section 18 of OSHA. The state's always free to preempt OSHA by asking permission to create its own safety plan and then doing it, and then it's up to the federal government whether that complies enough with OSHA.
So the crux, I mean, one of the grounds here, and it seems to me maybe one of the most important grounds, and you may disagree as a fact matter whether the board established this, was that the dentist didn't do regular spore testing, which is designed to ensure the safety of patients. Forget about the workplace. Patients. Because it will ensure the sterility of the tools that they stick in your mouth. Could the board do that? Why can't the board do that?
The board can do that. The spore testing is not an OSHA regulation. It's a CDC recommendation, and then the question is whether this is one of those recommendations that the CDC says is a requirement or a recommendation.
Why does it matter what CDC says? Why isn't that what the board says? The failure to do so is unprofessional conduct. The failure to follow a spore testing regimen to protect the safety of the customers is unprofessional conduct.
Well, it seems to me you have to have some kind of notice about what laws and standards you're supposed to comply with ahead of time. You can't, as happened to Dr. Chadwick, find out after the fact that, for example, OSHA says I can throw these carpules, these anesthetic cartridges in the trash, but I suddenly find out, and all the witnesses say that I can do it. And by the way, I haven't been throwing them in the trash, but now I come to find out that the board suddenly announces a new standard where I'm now required to throw them into a sharps container. I mean, you can't be required to guess and then find out after the fact that your license is being suspended because of a standard that you had no chance to know about.
Okay, no, that's understandable. That makes sense to me. So this requirement of spore testing was something that no one understood to be the case?
No, the requirement of spore testing was part of the CDC regulations. It's not part of OSHA. It's not part of our OSHA argument. The argument with regard to that claim alone, that stands by itself, is simply that there were disputed issues of fact. And ordinarily, the board would be the trier of fact, and we wouldn't disturb their credibility determinations. In this case, however, the board explained what the basis of its credibility determinations was. And it said over and over again, if Dr. Chadwick doesn't understand OSHA, then we are free not to believe anything he says, or any testimony that's favorable to him. So, for example, again, he says, and his people say, yes, we did spore testing. Yes, we kept records of the spore testing. Here's how we did it. They have a photograph, and you can look at it yourself when the CDC folks came into the office, of a spore test kit sitting by his sterilizer. He didn't know they were coming. He didn't put it out there. That's just for them. It was sitting there. They felt free to disregard their own photograph and their own testimony because they felt that if he didn't agree with them on OSHA, they could make that impermissible credibility determination. So on that one issue, you could send it back to the
And I take it that the only evidence that he wasn't complying with it was a statement that he allegedly made to one of the investigators? That's
right, and he denied making it, and his medical, the other people that were in the office who were there during the whole time, despite what the board found, said that he didn't make the statement. And
But
in
you're
fact,
not saying that the board is required to believe them, because there were more of them that said that.
no, absolutely. I'm saying, I've just said that the board is entitled to make credibility determinations, but I'm saying that in this case, the credibility determinations are tainted by the board's statement that we are making our credibility.
And you're saying that even taints this one about he did or didn't say this particular thing.
Exactly. We don't believe anything that he said because he doesn't understand OSHA, and they say that over and over and over again. And I think they even say it with regard to the spore testing.
So with respect to the spore testing stands aside, everything else is OSHA regulations?
That's right. And these are not, I've explained that even if you, we talked about metaphysics in the last case. I mean, even if you imagine this imaginary regulation that is identical in every way to OSHA, but yet is not OSHA, but is a state law, when you look at how the board gets to OSHA, the CDC regulations through which it has to pass to get to OSHA don't even say that OSHA applies as a way of protecting the public. It says OSHA applies as a way of protecting employees. And when you look at the specific OSHA regulations they say were violated, these aren't regulations designed to protect the public. These are training regulations. These are regulations about whether employees should get a hepatitis B vaccination. These are regulations about how employees should handle hazardous waste. Now, there may be a second benefit to these regulations, and GAID talks about these dual-purpose regulations, and it says it doesn't matter if this is a dual-impact regulation. If it is an area in which OSHA regulates, then the states are without power. And there's a case that Justice Gantz wrote in the Superior Court, Mass Electric, that basically says the same thing.
Well, the CDC report speaks of recommendations that regard not only educating and protecting dental health care personnel, but also preventing transmission of bloodborne pathogens.
That's right.
The latter is patient-related.
Absolutely.
Okay, but I guess I gather the only reference to OSHA is before the recommendations are cited. It's on page 43 of the appendix, as far as I can tell.
Right. OSHA is, I believe OSHA is, certain OSHA regulations are cited elsewhere in the regulations, but what the Commonwealth relies on is, right, the one on page 43 of the appendix, of the Commonwealth's appendix, where it says, these programs should be followed in addition to practice and procedures for worker protection required by the Occupational Safety and Health Administration standards, so for occupational exposure. So it's clear that when the CDC cites OSHA and the way that the Commonwealth gets to OSHA is only in connection with the protection of workers and not with the protection of the general public. And in that case, the regulations are preempted, if they existed, which they didn't. Now, interestingly, the board realized that it had a problem in the way it got to OSHA, and they've now amended their regulations to say all dentists have to comply with OSHA. So you could actually decide this case by saying the old regulations were defective in the way that they cited OSHA, and the new regulations aren't. But I don't think you should do that. I think that you should find that OSHA regulation is preempted, because the fact is that the board does not have the expertise to interpret these regulations. The interpretations that they come up with are bizarre. Back again to the carpules. OSHA says that these glass cylinders are not medical waste and can be thrown in the trash. Dr. Chadwick's expert, a professor at the Harvard School of Dentistry, says these are not medical waste. The board's own expert says these are not medical waste, but can become medical waste if they break, but these ones that we're talking about weren't broken. And yet the board finds, with no basis at all, that they are medical waste. And then, of course, they have a picture of a sharps container that's filled with these things, and they say they don't even address it. They don't. But what they say implicitly is, we're not going to look at the picture our own investigator took because we don't believe anything that is favorable to Dr. Chadwick because he doesn't understand OSHA.
So if they're not medical waste, why were they in the sharps container?
Dr. Chadwick is certainly entitled to throw anything that he wants into a sharps container if he feels that it even has the potential to be medical waste, but the fact is that they weren't medical waste. And a similar finding, and I see my time is up, has to do with the gauze. Everyone testified that if there's a little dot of blood on a Band-Aid or a piece of gauze, it's not medical waste. The board uses, and Dr. Chadwick says the same thing. The board says it is medical waste, and because Dr. Chadwick doesn't understand it, we think he's throwing medical waste in the trash, even though there's a photograph that their own people have taken of his medical waste container.
Thank you.
Thank you.
Good morning. My name is Amy Spector. I'm an Assistant Attorney General, and I represent the Board of Registration in Dentistry. In addressing the issues, both of the issues raised by Dr. Chadwick, it's important to keep in mind that the Board is charged broadly with protecting public health, in particular by regulating the practice of dentistry in order to ensure that patients are safe.
Well, let's talk about this, because much of this has got to do with, it seems to me anyway, employee safety. Much of what's going on here is about employee safety, not really public safety.
Well, I don't think that that's correct, Your Honor. It is true that, well, first of all, the most egregious violation at issue here, the spore testing.
Let's leave spore testing aside for a second.
Okay, leaving spore testing aside. I think that really, in spite of, with due respect to Mr. Rosen's argument, the worker provisions here, any effect on worker safety is really incidental to what the board is about. And when the board, as Your Honor pointed out and really encapsulated our argument, the OSHA has no authority over state-issued licenses. And contrary, I think, to Mr. Rosen's suggestion, certainly OSHA doesn't have the resources and not the mandate to go inspect every dentist's office in the land, and has no authority to take any disciplinary action against the state-issued licenses of dentists. So the result of finding preemption here would be that, notwithstanding the absence of any federal authority to act against a state-issued license, the state would essentially be unable to restrict the practice of a dentist who the state found had violated standards, which, as Justice Spina suggested, the board could have just lifted or plagiarized.
But can the board set standards for practice in a dental office that are different than OSHA, stricter than OSHA?
Well, I think that that's an issue that the court doesn't have to address here. I mean, here, I think that they might be able to if the effect on worker safety were so incidental, because what the Supreme Court said in Gade was that all that was preempted is state law that specifically, they used the word specifically, substantially, and clearly and directly, is aimed at addressing worker safety. So that was the case in Gade, where there was a conflict. What the state did was imposed, I think, 500 hours of some sort of training on workers, where the federal government had imposed just 3 hours. And so both regulations in that case clearly were aimed at the same thing, worker safety, and there was a conflict. Here you have an entirely different situation where what the state is interested in and what its mandate includes is to protect the public safety, in particular the patients who go into a dentist's office and need to be assured that the instruments that are being used are sterilized.
I understand the instruments. It's some of this other stuff. Failure to keep records of hepatitis B vaccinations for office staff on a particular form. Annual training for the office staff pursuant to 29 CFR. I take it that has to do with what, handling hazardous waste? Written exposure control program for the office staff that did not comply. All that sounds like sort of work conditions, not
Well, I think some
public
of that.
safety.
I'm sorry, I didn't mean to interrupt.
No.
I think annual training certainly sounds a lot more far afield than spore testing. I agree with you. But I think that actually all of the regulations that the board seeks to impose have to be and are grounded in patient safety. I mean, for example, hepatitis is a contagious disease, and so the ensuring that workers have the vaccinations, not only, it's true that that does have the incidental benefit of protecting the workers themselves, but it also protects patients from transmission.
I just want to pause there for a moment, because I'm listening to you focus on some of the language in GAID, but not other language, which I think helps to clarify what that specific might mean. And that is that it can't just have as part of its intent and focus workers, but on the other side, that they apply to the public at large, so as to not only focus on workers. And that doesn't really happen with the regulations we're talking about, right? In that way, there would be non-specific regulation and thus not preempted.
Well, I think that I'm not sure I understand.
It's not enough to say we intend for these to work in this specific category and thus not be preempted. You have to look more broadly.
I think what the court was saying, it's necessary to look at sort of the whole picture. And here the whole picture certainly is that what the board's interest and mandate is to protect the public health broadly. And it is true, of course, that some of the regulations here seem less related to patient safety. I would concede that they are along the spectrum, annual training probably being the most obvious. But stepping back and looking at the big picture, it's really quite hard to imagine that in enacting the OSHA statute, Congress could have intended to displace the states from exercising what is, after all, their historic police powers to enforce a public health matter by taking disciplinary action.
But let me read you part of GAID. We recognize that the states have a compelling interest in the practice of professions within their boundaries, and that as part of their power to protect the public health, safety, and other valid interests, they have broad power to establish standards for licensing practitioners and regulating the practice of professions. But under the Supremacy Clause, from which our preemption doctrine is derived, any state law, however clearly within a state's acknowledged power, which interferes with or is contrary to federal law, must yield. We therefore reject a petitioner's argument that the state's interest in licensing various occupations can save from OSHA preemption those provisions that directly and substantially affect workplace safety. Isn't that as clear as it can be to say that you're wrong? I mean, that's the language of GAID, which I don't think you cited.
I
mean, you cited it. I don't think you addressed that.
Well, I did
paragraph.
cite it. I was surprised that the plaintiff didn't cite it because I was troubled by that language when I first read it. But I think that that language, when read in the context of the court's whole opinion, and in particular, I found that language difficult to decipher, to be honest. But I think when it's looked at in conjunction with the use of the phrase directly and specifically and substantially, it seems to me that and again, looking at the congressional intent being what's referred to as the touchstone of the analysis, and also taking into consideration the historic, the presumption that where the police power is involved, preemption is not intended. It's just hard to imagine that Congress could have intended that not just dentists, but doctors and other healthcare professionals would be completely immune from disciplinary action against their state-issued licenses that, after all, the federal government has no authority over, simply because the state, in addressing an issue of public safety or patient safety, has decided to use the same standard as the federal government. Perhaps an issue could arise in some case where the standards were conflicting, but that's not this
But couldn't
case.
you don't you have the alternative of the 18B plan? I mean, and to say that there's just no way that the professions could be regulated absent this, it's just, there's an alternative.
There is an alternative, but the state...
The state chooses not to do it.
Right. I think that... But again, that's directed at...
But Congress provided that alternative. So when you talk about congressional intent, Congress provided an alternative for states who wanted to do things differently.
Yes, but again, I think that that's related to the issues of specifically worker safety, so that the state could decide to submit its own plan governing how employers should treat employees with respect to the full range of the kinds of things that OSHA addresses. I don't think that that language is intended to encompass the kind of professional licensing. I mean, the board mandate to regulate the conduct of dentists includes a lot of things that couldn't even possibly be OSHA related. And so I think that aspect of OSHA refers to clearly occupational type issues that the state could choose to, but hasn't in this case chosen.
But the Commonwealth could also revoke licenses based on a federal conclusion that OSHA standards had been violated.
I think that it could, but our position is that it doesn't have to wait until, and I think as a practical matter, making the state wait until the federal government had found a violation would essentially gut the whole professional licensing statute, because OSHA simply doesn't have the resources and to go into every dentist's office throughout not only the Commonwealth but across the country.
Do you disagree with counsel for Mr. Chadwick that the board has actually interpreted the OSHA regulations differently than OSHA has interpreted them?
No, I don't. I don't agree with that. I mean, I guess
about this hazardous waste, little dots of blood on bandages and gauze, whether it's hazardous waste or not.
Well, if I can address that and for a moment and get to a little bit into the substantial evidence issue. I don't want to wade in too deeply because there's so much to wade through here. Okay. But I would like to just highlight a few of the key facts. First of all, well, I know you said maybe we could set aside the spore testing with respect to the preemption issue, but even if the court wants to just focus on the most egregious violations here, the evidence on the spore testing issue, which has nothing to do with OSHA, was quite clear. This is the violation that the board found was the aspect of his dental practice most likely to have the most serious implication for patients. And the evidence was more extensive than the plaintiff suggests. There was the testimony of the board compliance officer that Dr. Chadwick told her that he hadn't been doing spore testing. The written report of the first inspection says no under spore testing. Dr. Chadwick, I don't think this is something I mentioned. I'm afraid I neglected to mention this in the brief. Dr. Chadwick himself signed this report, this inspection report. This appears at page 171 of the administrative record, and thereby acknowledge the accuracy of the report. So even if we just focus on the most egregious of the violations and the one that doesn't have any implications for OSHA, he admitted it. He also admitted on his own testimony. He was asked whether he kept written records of spore testing before that July inspection, and he said no.
Can I ask you a question? Is keeping written records a requirement of CDC, or what's it a requirement of?
It is a requirement. Yes, it is. Yes, the CDC guidelines do require that written guidelines be kept. I think that those may. I think that requirement refers in turn to state and local requirements and of record keeping. And the board had previously found in the Abrahamson case that not only is weekly spore testing required, but that records must be maintained. And so even based on his own testimony, the testimony of the board compliance officer, the written report that he himself signed, there's enough there to find that he did commit what the board found was this most egregious of the violations. With respect to the bloody gauze, he does not even challenge that aspect of the board's decision that refers to the most serious aspect of this, which was material that even Dr. Chadwick conceded was medical waste, that is, gauze that was saturated or soiled with blood. He does not challenge here the board's finding that his practice in that regard did not comply with the CDC and DPH regulations. He does spend a lot of time talking about gauze that had only a small amount of blood on it. However, On that aspect, too, the written report refers to the board's inspectors having discovered what the report refers to as medical waste. And he signed that report, not something I had mentioned in the brief, but wanted to bring it to the court's attention. The very board inspectors who had an opportunity to see what was going on at the office concluded that his disposal method of placing this material in a bleach solution was not sufficient. So I think that the evidence quite clearly is there, and especially if the court focuses on these most egregious of the violations, that is the disposal of the bloody gauze and in particular the spore testing, there certainly is more than enough evidence to support the board's conclusion.
Now, if I can turn you back to the regs speak about all persons licensed by the board and all offices providing dental services shall be required to provide services in compliance with the recommended infection control practices for dentistry 1993, published by the CDC. Then we have a 2003 document which has substantial text and then later recommendations, some of which are recommended, some of which said should be required. What do you say have been incorporated by reference into that regulation? The entirety of the guidelines, or only those recommendations, or only those recommendations which are said to be required for implementation?
Well, I think that the state regulation refers to the CDC guidelines. I'm sorry, I don't have the regulation in front of me, so I can't recall whether it actually specifies the infection control portion of the...
Well, I've got it before me. It says in compliance with the recommended infection control practice for dentistry, that was 1993.
Right.
Now the 2003 document is called Guidelines for Infection Control, but it contains much later specific recommendations. So is it your view that only the recommendations are incorporated, or that all of the entire text are to be incorporated by reference?
Well, I think the recommendations I viewed when I looked at that document as sort of a summary and consistent with the rest of the text to follow. And then I would just point out that the CDC guidelines do themselves in turn refer to by incorporation the OSHA standards, but it's really the fact that they're guidelines is really irrelevant for the purposes here. The state board has made it entirely clear that the state board considers these requirements to be mandatory. So the exact phrasing of the CDC guidelines as guidelines is not, we don't think that that's a problematic in terms of the board setting the standard here.
So your answer is everything is incorporated?
I think so, yes.
All right, thank you very much.
Thank you.